Right. We did, Minister, discuss this issue at committee stage. It is, to my mind, one of I have a number of amendments, but this one is one of two that I see as being the most important. The objective of this amendment is to place an upper limit of 3 months on the time that a child can spend remanded in custody. And I'm very much moving it in the context of the rest of the bill, which is to move away from the issue of detaining children who get into trouble. Now, custody on remand is detention in circumstances where a person hasn't been convicted of a crime and may never be. And I think we need to very much bear that in mind. It should always be a minimum for everybody, to my mind. The Irish Penal Reform Trust recommends 6 months as the absolute maximum in all cases. What my amendment seeks to do is to put a limit of 3 months, because I think 3 months in the context of a child's life is perfectly balanced. Now, I think we should remember and mark the fact that of the children who are in custody on remand, 4 out of 10 of those children have an intellectual disability. Often they come from families where one member of their family had a criminal conviction. The majority of these children have behavioural problems, mental health difficulties and so on, and often experience drug and substance abuse. So these are vulnerable young people who need our support. And I don't believe that we can in any way stand over or have a situation where they're detained for periods of indefinite duration. So what my amendment seeks to do is put a time limit on that period. I think the most important things are that most of these young people never end up getting a sentence anyway. In 2014, only 27% of those young people detained got a detention order on conviction. In 2013, it was 45%. So less than between a quarter and a half never end up getting a conviction anyway. Most don't. And we have to keep their time incarcerated to a minimum because of the damage that potentially does for young people. And while we're on the subject, the issue did come up at committee, but the idea of when children are remanded in custody, the separation and the need to separate them from those who have been convicted is incredibly important. Now, the bill as it stands says we should seek to do that as far as is practicable. I wanted that in all circumstances, and the Minister said at the committee that she were striving to do that, but that we wouldn't have the level of accommodation necessary for that. I think the reality is there's no assigned remand unit on the Oberstown campus. There's been consistently high numbers of children remanded, which would mean the issue that you raised at committee of solitary confinement wouldn't arise. Look, the whole bill is supposed to be about prevention. These young people need a sustained intervention. One of the problems is somebody being remanded in custody, for example, for breach of bail conditions. This has to stop. Again, we said this as committee. People, when they're put out on bail, are not given the sufficient support to be able to understand those conditions, to work with them and so on. We need community programmes, non-detention based initiatives have to be implemented while people are awaiting trial, and this amendment encourages that. All this is about is an upper limit, less wriggle room for the state in that regard. The Minister said in committee that what I was trying to do was a blunt instrument, that it wouldn't take into account the circumstances that gave rise to the remand in custody, that very serious charges might be a factor, the issues of the importance of the safety of the public. Well, putting an upper limit on the time somebody can spend on remand has absolutely nothing got to do with any of those issues. I'm not saying don't detain them. I'm saying deal with their trial, detain them for a maximum of 3 months and then deal with it. And if they're convicted then and there is to be a period of further detention, fine, so be it. But don't keep them in abeyance in the run-up to that. And that is entirely consistent with human rights practices, and it's entirely consistent with what happens in other countries. I won't go on about them. I could list out a whole range of international human rights agreements which support my view. I could talk about the fact that in England, for example, such a practice of limiting times on custody custody and remand to 6 months exists. In Spain, it's only for very serious crime, never for minor offences when we're dealing with children. The maximum length in custody is 3 months. In Portugal, I think similarly 3 months as well. So that's all I'm seeking to do here, Chair, and I really hope that the Minister would revisit and reconsider that.
Thank you,